Okay, good morning, good afternoon, and good evening. My name is Kernahan Webb, and I am a professor in the Law and Business Department at Toronto Metropolitan University. And more importantly, for today's session, I am the director of the Toronto Metropolitan University Institute for the Study of Corporate Social Responsibility. For those of you who are patching in for the first time, welcome. For those of you who are making a return engagement, welcome back. We're very fortunate today to be exploring Nigeria's new legislated approach to impact and benefit agreements. And we're fortunate to have as our guest speakers on that topic, Lutana Nwogo and Ibrahim Yuku, both of whom we will be speaking to in a moment. I'm just going to go through some preliminary information first. First of all, noting that this session and generally all sessions of the CSR Institute are co-sponsored by two excellent student organizations at Toronto Metropolitan University. Those are the TMU CSR Student Society and the TMU Law and Business Student Association. All of these sessions are held in the spirit of constructive engagement. That is to say, we are exploring how it is we can optimize the positive impacts of industry, while at the same time minimizing the negative impacts. And how can we do that? Through a combination of legal approaches and also industry approaches and civil society input and so on. How combined those can potentially lead to optimal situations with benefits for the communities, the countries, the companies, and the environment, as the case might be. Next slide, please. Toronto Metropolitan University is located in Toronto. Toronto is in the Dish with One Spoon territory. The Dish with One Spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee peoples that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. I'll just note as well that Toronto Metropolitan University used to be known as Ryerson University, and so now it's known as Toronto Metropolitan University. So my apologies in advance for anyone who is confused about that and is wondering what's the connection between the one university and the other university. We are one and the same. Next slide, please. All TMU CSR Institute sessions are animated by this definition of social responsibility, which comes from ISO, ISO being an international non-state, non-governmental body that brings together public sector, private sector, and civil society organizations and individuals to develop standards that are voluntary, that are intended to assist in cross-border activities that minimize the negative impacts and enhance the positive impacts. And within this particular standard called ISO 26000 Social Responsibility, that is a guidance standard. It's over 100 pages long, developed by a combination of governments, intergovernmental bodies, the private sector and civil society from both the global north and the global south. And through a consensus process, one small but extremely important development in this ISO 26000 standard was its consensus definition of social responsibility, which you see here, noting that responsibility involves considering the impacts of an organization's decisions on society and the environment, not just on the company itself, through transparent and ethical behavior, contributing to sustainable development, which is development that meets the needs of current generations, while also considering the needs of future generations. and addressing issues like health and welfare of society. It's all about taking into account the expectations, not just of shareholders, but also of all other stakeholders. It's definitely based upon compliance with all applicable law. Companies should be complying with all applicable law, but also should be ensuring that their activities and decisions are consistent with international norms of behavior. For example, the principles for responsible behavior set out under the UN guiding principles for business and human rights, the UN Global Compact, and a variety of other international standards that have been developed and are widely implemented. And finally, CSR is not just about integrating the concept within the organization itself, but also practicing it in its relationships with others. And we're going to see how, in this particular case, Total, the Total Energy Company, is attempting to address this with varying degrees of success, and how it is also attempting to comply with the evolving laws of Nigeria and the international normative environment as well. Next slide, please. The second key concept that animates all TMU CSR Institute sessions is the concept of sustainable governance, which is this idea that in the 21st century, where we're faced with challenges that are multi-jurisdictional in nature, they don't neatly fit just within one country, for example, environmental issues like climate change. And also, they tend to be fast-moving, very complex, and they have environmental, social, and economic dimensions to them. So given that these are the sorts of challenges we face in the 21st century, the idea behind sustainable governance is that in order to address them effectively, that's going to take harnessing the unique energies and capabilities of all three of the public sector, the private sector, and civil society, using a combination of rule instruments, and processes, institutions, and actors. And we will define those terms in a moment. And sometimes that means operating collaboratively, and sometimes that means operating in more of a rivalrous check and balance manner. And both collaboration and check and balance dynamics are important for innovation and ensuring that activities are done in the most up-to-date way. Next slide, please. Just to expand on the sustainable governance idea, it consists of, as building blocks, these four concepts: institutions, rule instruments, processes, and actors. Institutions means things that we're all familiar with, such as legislatures, but it also means specialized entities in the private sector, such as ISO, that, for example, develop standards. So those are institutions for the purposes of the sustainable governance concept. And then there are rule instruments. And again, rule instruments consist of, yes, legislation and regulation, but also of non-state rule instruments, such as industry association standards, individual company codes of conduct and policies and so on, as well as things like ISO standards. It involves processes such as rulemaking, but also rule application, rule implementation, and decisions with respect to penalties, awards, compensation, redress, that sort of thing. And again, those processes can be public sector processes. Those processes can be processes associated with industry association rulemaking and rule implementation, or ISO rule implementation, rule development, rule implementation, and so on. Finally, sustainable governance involves a cross-section of actors, interacting actors. So inspectors, judges, auditors are all individual actors. And then things like the United Nations and the Nigerian Legislative Assembly and the Nigerian Petroleum Association, those are all also actors. Okay, next slide, please. Just to let you know that we are constantly coming up with new topics for discussion. We have one coming up on January 27th, which is next Tuesday, and that is concerning the Australian government response to the Bondi Beach tragedy. And we'll be talking to Professor Benedict Sheehy of the University of Canberra Law School about that. So that's on Tuesday coming up. And we are constantly posting new sessions coming up in the future. We have an ongoing project which is exploring the rule of law and what can be done to ensure the rule of law is followed and the international rules-based order is followed in these tumultuous times that we're experiencing at the global level. So the rest of the slide is basically just noting that there is a lot of things happening here at Toronto Metropolitan University that are could be of interest to those of you who are patching in here today. And just generally, whenever you want to know anything about the TMU CSR Institute, all you have to do is just Google exactly that, TMU CSR Institute, and that will take you to the webpage where you will see all this information that we're talking about here now. Next slide, please. So we're very pleased to have two speakers here today, Ibrahim Yiku, and he is a distinguished lawyer with more than 17 years of experience spanning both private legal practice and in-house counsel roles at the law firm of Solola and Akpana and Total Energies, EP Nigeria. And he possesses deep expertise in oil and gas law, complex litigation, grievance management, host community relations, contracts and procurement, and regulatory compliance. And he's got his bachelor's degree in law, LLB, from Lagos State University, and a BL from the Nigerian Law School, and an LLM in compliance and risk management from Thomas Jefferson School of Law in San Diego, California, serving on the editorial advisory board of the Compliance Professional magazine. And he's a country advisor for the International Due Diligence Organization. Next slide, please. And we're also pleased to have Lotana Nwodo, and he has a bachelor's of law degree in Nigeria and a master's of law degree from Harvard. He is legal counsel at Total Energies, where he provides strategic legal advice on energy law, energy transition, and energy policy for the company's upstream and downstream operations. He's co-authored the Nigeria chapter of Directors' Liability, a worldwide review, and he's written several scholarly articles. He's the co-founder of the Bridge Healthcare Access Initiative, which is a nonprofit organization procuring access to primary healthcare for underprivileged Nigerians through enrollment to health insurance, among other strategies. And he's speaking in his personal capacity. Next slide, please. So about this session, so Nigeria's Petroleum Industry Act of 2021 and then subsequent regulations, such as the Nigeria Upstream Petroleum Host Communities Development Regulations, requires oil and gas companies to financially support their host communities through something called Host Communities Development Trusts, HCDT. We'll be talking quite a bit about that. The trust mandates that a percentage of an oil company's operational expenditure be directed toward development projects in the communities where they operate. And it's a requirement for every company holding a petroleum prospecting license or mining lease, with a portion of the operational costs designated for community development. And the fund is intended to support the sustainable development of the communities that are impacted by oil and gas operations in the upstream, midstream, and downstream sectors. And it could be said that the Host Communities Development Trust approach represents a distinctive, structured Nigerian approach to the diverse approaches to impact and benefit agreements that are being developed around the world. And this session is devoted to exploring the background leading up to, the terms of, early results from implementation of, and future prospects and challenges associated with the Nigerian Host Community Trust Development Trust approach, pardon me. Next slide, please. Just a note, we have people patching in from around the world, and therefore they are in different time zones. A particular tip of the hat to those of you who are patching in from far off places, far off from Canada, where you are patching in at odd times of the day and night. Props to you for doing that. Just a note to all of you, whether you are in government or the private sector or civil society, that if you do have a comment or a question, if you could email me, I will be monitoring that throughout the talk, and I will do my best to fold in your questions and comments into the conversation that is now about to begin. So with that out of the way, thanks very much, Luke. Let's turn to and welcome to Lotana and Ibrahim. I guess the first thing I would like to say is perhaps you can just unpack a little bit more about how it is that you both, each individually, how it is that you decided to pursue a degree in law, a path in law, the practice of law, and how did you end up in specifically working for Total Energies? If you could just expand a little bit about on that. I always find that is interesting to the people participating in these sessions, because what I find is that everybody seems to find their way to this space, this corporate social responsibility space, through diverse paths. And I'm anticipating that the same will be true for you, Lotana and Ibrahim. So I'm not sure which of you would like to proceed first. Maybe you, Ibrahim, would like to speak first. So please do tell us a little bit about how it is you came to work for Total and selected the legal profession. And welcome.
Yeah, thank you very much for having me. Just a background on how I found myself in the study of law, eventually in the practice of law. I was a child volunteer to UNICEF under a local NGO. So we're pretty much in child right advocacy, going to secondary schools and villages and supporting UNICEF initiative. So at that point, I was introduced to the concept of child rights, um, community development, and having participated in several workshops and seminars organized by the local NGO. I thought it wise that the best path for me to pursue is to just be a lawyer. And that was the beginning of the interest, and I put in for law. And while in the university, I participated in several activities aimed at advancing the rights uh, of children. And I was still very much involved in the UNICEF activity at that time. So fast forward, the journey into law, finished the law school, and I started my practice with the law firm of Solova and Akpana. And at that time, I was representing the IOCs, international oil companies, in defending litigation matters involving communities. So that was another angle, another introduction to the concept of community rights, agitation, and protection. At that time, I was on the other side, on the side of the IOC, looking at the community as more like a claimant, representing the company as a defendant. So years after, had the opportunity to join Total Energies in-house, and that's started a journey of seeing how it's done internally, the commitment of the company to community and all that, and it's been pretty good. But more importantly, and I would say this, I remember having a presentation in my university days on environmental law and environmental rights. And the idea I had of the host community and Niger Delta was so terrifying that everybody in the community are dying as a result of oil spill. Coming down to the Niger Delta myself, I discovered that it's not really the case, that both the community and the IOCs both have role to play, or are both in a way have common shared responsibility in preserving rights, environmental rights, and the environment in particular. So that's it for me, just to be brief.
No, that's terrific, Ibrahim. Thanks very much. I do find it interesting, first of all, of your initial work with UNICEF. We have had several sessions on UNICEF and the work they're doing with respect to protecting the rights of children from a business angle in particular. You are sort of building on that experience yourself, and that's very interesting. Also interesting is the fact that you have been on both sides of the table, so to speak. So you have appreciation for the interests of both sides and an understanding of that. And then finally, as a legally trained person working for a law firm, you're in a position to see how it is things like laws, but also company codes of conduct and policies and so on, how they get translated into practice within the firm and then implemented in the broader community. And all of that is very much in keeping with that concept of sustainable governance that we looked at earlier, where we're talking about how everybody's got a role. If you want to have in any area that you can think of, if you want to have a effective approach to it, it typically involves governments, the private sector, and civil society, and each of them have got unique positive roles that they can play in that regard. So thanks very much, Ibrahim. Over to you, Lotana.
Yeah, thank you very much. I wish I had something interesting as Ibrahim. Mine is less dramatic, I would say. So I was in the sciences actually. So in my high school, I focused more on physics, chemistry, and so on and so forth. But I've had a lot of influence from my father, who is also a lawyer, and an uncle of mine, who is also a lawyer. So that's influenced me eventually to study law. And I mean, nothing really, I would say there was nothing pulling me into law, but when I got into it, I found it rather very fascinating. I think my first introduction to oil and gas and the community engagements was in my environmental law classes, where we studied a lot of litigation, that between oil and gas companies and host communities. At that time, my impression was that the oil and gas companies were, I mean, they were really very, use the word, they were the devils, right? Because of it, in many cases, the judges ruled in their favor, even when you could see clear causes of action, on the part of the host communities. After graduating from universities, I joined the law firm of Aluko and Oyebode, initially in Abuja, which is the capital of Nigeria. And then eventually I moved to the Lagos office, where I focused a lot on mergers and acquisition. Some of our clients were oil and gas companies, but that was not really my introduction to the oil and gas sector. That would eventually be when I was selected as a Power Africa fellow, under the auspices of USAID then. And I worked with I had the opportunity to work with a New York law firm, Sullivan and Cromwell, for a few months. And that was when I handled a lot of projects in the oil and gas sector. So upon returning to Nigeria, I went out in search of opportunities to work in an oil and gas company, and I got employed in Total Energies in 2020, and I've had quite a diverse experience because of where I sit. I advise the corporate arm of the business. So I kind of advised on M&A transaction, on day-to-day corporate governance, and also with Ibrahim also work on the host community aspects of of our day-to-day operations.
Terrific. I know you're also the co-founder of the Bridge Healthcare Access Initiative, and I don't want to delay us talking about what we will be talking about momentarily, but the HCDT and related things. But can you tell me when it was that you decided to co-found the Bridge Healthcare Access Initiative?
Yeah, so the Bridget was an initiative that I co-founded with my wife, who I hope is listening. Yeah. Yeah. So I mean, the idea was there are lots of medical interventions by charity organizations in Nigeria trying to to ameliorate some of the medical needs of underserved Nigerians. What we tried to do was to come up with another way of doing it, which is instead of doing some ad hoc interventions, setting up tents and attending to persons, we instead would crowdsource the insurance premium and get them enrolled for 1 year. We noticed that that was more sustainable, because even the cost of setting up those medical, outreaches, we believe could, get more people, could impact more people and also cover them for a longer period of time than just the 1 or 2 days of intervention that's experienced in those outreaches. So we came up with the idea. Ibrahim is one of our big benefactors, so thank you, Ibrahim. But we've covered up to 80 people, and we're trying to grow them, year on year. Thank you very much for pointing that out.
Well, but Lieutenant, when did you initially come up with the idea for the Bridge
Okay.
Healthcare Access Initiative?
That was in 2024.
Okay.
That was in 2024. We got it registered in 2024, and it's been up in operation since then.
Terrific, terrific. Okay, well, thanks very much. So let's turn things over now specifically to the situation in Nigeria. If we can speak in general, kind of maybe if you think of this as like a bird at a very high altitude, let's just talk about Nigeria. Then let's talk about the petroleum sector. Then let's zero in on companies like Total, their evolving experience, and then finally we'll get down to the law prior to and now, the PIA as it exists now with amendments brought in. If we can kind of work our way down into the details of how it works, but first of all, set the scenes to some extent.
Okay. Would you is it a time would put up our presentation, if that's okay?
Absolutely.
Okay.
Please do.
Okay, so we prepared a presentation we hope would guide us through the conversation. Let me know if it's visible from your end.
It is visible. It is visible.
Okay. Okay. Okay, so I will not delve into the introduction. I think you've done a very good job in introducing both the concept of CSR as well as the evolutions in that aspect. I think the only points I wanted to just point out here is yes, indeed, a lot of countries are beginning to implement mandatory CSR. So it's the concept of CSR is evolving from from just being charity as it was considered very at the early days, to becoming a crucial strategy tool for company in their engagements with their stakeholders. And at this point, when we were talking about it in the context of being a legally mandated obligation, of companies. So you've also talked about, you've already given the background to the Host Community Development Trust, which is set up under the 2021 Petroleum Industry Act. So the scope of our conversation would split it into 4 large categories. The first would be to lay the background, to give a broad background about Nigeria and how the issue of how CSR matters in reckoning oil and gas operations in the country. We also describe the CSR approaches, pre-PIA, and then we'll talk about, then we'll then delve into, have a deep dive into what the ACDT is, and how that has changed, the CSR, the CSR outlook in Nigeria. And then we'll close with some conversations. I think maybe we would have some more interactive conversations around our early results, what you perceive has been the early results of the introduction of this legislated approach. And then also we talk about what the outlook is, from our perspective. So we think that the best way to start will be to talk about the country, Nigeria, how Nigeria came about, and how the minerals and oil and gas, the role it's played in the early days of Nigeria. As many Nigerians will always say, the beginning of Nigeria was in 1914, when two distinct British colonies, the northern Nigeria and southern Nigeria, forgive our typo there, were amalgamated into one for administrative convenience, as well as for the economic reasons of balancing the budget deficits of northern Nigeria with the surpluses of southern Nigeria. At that time, the colonial governments recognized that the southern Nigeria had a lot of resources. Before oil, there were a lot of agricultural products. There were rubber plantations, there were palm oil plantations as well. So the activities in the southern Nigeria was supposed to subsidize the cost of northern Nigeria. But then one interesting thing to note is that even at that point in 1914, which was decades away before oil was discovered in commercial quantity in Nigeria, the idea of oil in southern Nigeria was also played in the mind of the architect of amalgamation, who was Frederick Lugard. So the amalgamation of Nigeria, to just wrap up the slide, it laid the foundation for the federalization of oil and gas resources. Otherwise, if not, there would have been a more concentrated use or enjoyment or benefiting of oil within the areas where they are produced, instead of a bigger a country as we have it currently in Nigeria.
Lotana, just to be
Okay.
add in a little bit more, Nigeria is the most populous country in Africa and has the biggest economy in Africa. Is that correct?
Yes, that's correct. So we currently have over 200,000 people in the country. Is one of, we say it is the biggest economy in Africa. South Africa tends to disagree once in a while, but yeah. So, but we say we are the biggest markets in Africa, because as I say, any item that Nigerians adopt is going to be a huge commercial success. So we have South African companies actually that consider Nigeria as their biggest market. So yes, I think to be more exact, we are most populous in Africa, and also the biggest markets in Africa.
Very good.
Okay.
Please carry on.
So yes, so the next principle, the next thing I wanted to tease out also is the developments in how oil and gas, the role of oil and gas, how is considered as a national resources, as a national resource. So Nigeria then operated, during the colonial era, we operated a regional structure. There were three regions: northern Nigeria, western Nigeria, and eastern Nigeria, and they were all semi-autonomous, economically. So over time, Nigerians became more involved in the politics, and then even though the colonial constitution still maintained British government as the owner of all the mineral rights in Nigeria, they eventually recognized that all rents and royalties from any mineral belonged to the region where the mineral was derived. So this came to be known as the derivation principle. So if the principle as we had it then were to apply on this day, it means that all the rents and royalties derived from oil and gas based on this principle would have vested in the Niger Delta and the other oil producing states. The 100% of these rents would have been attributed to them. But as you will see in the next slides, this principle, this derivation principle, will change. And what triggered the change was the discovery of oil in commercial quantity. So in 1956, oil was discovered in commercial quantity in a place called Oloibiri. As you see in the picture, this is a sign showing the place where the first well number one, was drilled. So following the discovery of oil in commercial quantity, there was further conversation around the potential of oil and gas as a resource, as a major resource, for the whole country. So as a result of this, there was some change in the derivation principle. So there was a movement from the 100% as it was originally to 50% being attributed to region of origin, 20% being attributed to the federal government, and then 30% for the benefits of the other regions. So this showed a lot of kind of an understanding. Even though oil and gas at that point wasn't yet the mainstay of the economy, but it was a foresight into what it was going to be. So it was realized that if the 100% principle were to continue, the federal governments, the rest of the governments of the country may not benefit, fully from the oil and gas wealth.
Can you tell me, is Nigeria a constitutional federation? That is to say, the federal government has certain constitutionally allocated responsibilities and authorities, and the states or provinces, whatever they're called, have distinctive, separate constitutionally allocated authorities, or is everything just delegated from the center, from the federal government?
And so yes, absolutely. Nigeria is currently a constitutional federalism, and the constitution creates creates a distinct rule between the federal government and the state governments. So the federal governments, the powers of federal governments, they are all clearly defined in the constitution. So also the powers of the state governments. The constitution also defines the financial relationship between the states and the federal government. And but the stage what we're currently talking about was the stage we were talking about at that point was the colonial period. So at this time Nigeria hadn't yet gained independence, and it was in 1960, after oil was discovered in 1956, that Nigeria eventually gained her independence. And it was in this independence constitution that you would find the derivation principle of 50, 20, 30. So this was supposed to take into account the federal structure, that the regions, though where the oil was still located in the region, it was a recognition that it was all the oil, the rights in minerals, oil and gas, whatever the mineral is, still vested in the federal government of Nigeria. So the derivation principle is supposed to recognize the federalism, as well as also to recognize the regions where the minerals are being produced.
Very good. Thank you.
Good. All right. So another Another point to also know here is the conflicts. I think the conflicts played a lot of role in the evolution of CSR as a major tool in the oil and gas industry. So at this point, when Nigeria gained her independence in 1960, as I mentioned earlier, the derivation principle was clearly defined there. But in 1966, the country, the democratically elected government was overthrown, and then the military governments then operated a more unitary structure where the federal governments had all the majority of the power were then vested in the federal military government. So as a result of this, there was a high concentration of finances in the federal government. So in 1967, the governments, there was a feud, between the military presidents, the military head of state, and the governor, military governor of the eastern region. So following that feud, the military head of states then decreed abolishing the regional system and instead transited into states. So this was supposed to whittle down the powers of the of the governor of the eastern region. So in so doing, the military head of state also abolished the derivation principle. I would have also mentioned here that also this feud led into the Nigeria Civil War, and the oil and gas played a lot of role in the in the Civil War, but that will be a conversation for another forum. But then after the war, there were a lot of agitation from the Niger Delta people, a lot of movement, a lot of strong people, came up to to talk about the deprivation, the disregard that they were encountering, they were feeling, that the Niger Delta was facing in Nigeria. They felt they were marginalized. I was talking with Ibrahim earlier, and we talked about the Festac, which was a festival that was organized by Nigeria for Africa, which was a very huge and expensive project, and how the Niger Delta felt that the country was really living large to their own to their detriments, and they were being disregarded. Their economy, their environments were being disregarded. So this led to a lot of agitation from the Niger Delta, a lot of conversation with the military governments. And needless to say that there were lots of violence clampdown on these movements. So the most popular globally would be the killing, the execution of nine nine activists from Ogoni in the Niger Delta. So even after, so in 1999, Nigeria returned to to civilian rule once again. So the important thing here is that there was the derivation principle was reintroduced, and 13% of the wealth from derived from oil and gas was to be plowed back to the states where the state of origin of that resource. So now with 13%, there was an expectation that this would assuage the feelings of the Niger Delta. That did not. So in early 2000s, there were extended periods of armed militancy in Niger Delta that led to destruction of oil and gas facilities, kidnappings, and disruption of production. And this impacted a lot, impacted the oil and gas companies and the country a lot immensely. Okay, so it's within this context that CSR emerged as a risk management tool in the Niger Delta. Now the oil and gas companies, found CSR as an avenue for them to negotiate the terms of coexistence with the communities. CSR was also another way of filling the development gaps in the Niger Delta. It was indeed obvious that there were a lot of developmental deficits, in that region. So the oil and gas company felt that filling those gaps was one way of, assuring a peaceful coexistence between them and the communities. So it was also another way of getting the Niger Delta, the communities directly involved, because the oil and gas companies would directly reach out to these communities, have conversations on what their need, and this would then inform the CSR projects that the oil and gas companies would eventually implement. So it became a form of social contract, all right, between the oil and gas companies and the host communities, that as long as the oil and gas companies fulfill their commitments to the communities will allow them to operate peaceably.
So I understand it's a form of social contract. At this stage, was there ever any real, actual written contract between companies, Total, Shell, and so on, and individual communities where you set out, here's the company's commitments with respect to environment, with respect to investment in local infrastructure, training, jobs, that sort of stuff, or in this period prior to the introduction of the HCDT, was there any sort of effort by companies such as Total and Shell and others to formalize their individual relations with affected communities as a contract, legally binding or otherwise?
Yes, indeed, and that's actually is a very nice question, and it feeds into this the next
Very
slide.
good. Very good.
Yeah, what the tools that were used by the oil and gas companies were memorandum of understanding, or in some cases called a global memorandum of understanding. So prior to the PIA, this was how these commitments, these agreements between the communities and the oil and gas companies were epitomized. So however, it was still considered nationally considered as voluntary. However, it's it was quite is as I was saying, it's one of the big the um it was one of the tools that it, the company needed to show, before the communities are able to work, to allow them to work peaceably. So usually where there is no MOUs, you will see that the communities would rear up at some points, try to disrupt operations. So while it was voluntary, it's almost like a license that every oil and gas company needed to show for them to operate and to carry out their projects. Another point to also note is that they are couched largely as MOUs, even though the term, even though they are couched as MOUs and not as agreements. They have sometimes been enforced in court, depending on the aspects being litigated. So in some cases where the companies had made commitments, to commit a particular amount, and failed to meet up with that commitment. In some of the cases, the communities has succeeded in court to compel the companies, to fulfill that obligation.
Can you
Yeah.
just and did in any one of those cases, if there's, for example, a case which is particularly referred to, were the MOUs characterized as contractually binding, or do you know how they were characterized by the courts in those early cases?
So the approach of the court really is not to to consider the documents to see whether the document is legally binding documents or not, but like kind of they honed down on the obligations and the commitments that were made. So if the companies have made commitments and it's had affected or impacted on how the communities related with the companies, the courts would find that the companies were obliged, to perform their part of the deal. So not necessarily to declare that MOUs are binding, but that the obligations, certain obligations, based on how they have been couched and based on the circumstances, of the case. So the courts would find that those obligations, were binding in those cases. So not necessarily the document itself, but they will drill down to the obligations.
Okay, I'll leave that aside for now. But
Mm.
if the courts did find that these commitments were legally binding, it will be interesting, perhaps after this session is over, to go back and see what sort of legal analysis and characterization was used in order to hold companies to the terms of whatever those commitments were. If it's a license, that's one thing, right? So a license that comes from government, then the commitments that are made in the license are legally binding. If it's a contract, then the commitments are legally binding. If somehow or other the courts in Nigeria found the commitments to be legally binding, but they did not characterize them as contractual or as implicit terms of a license agreement, I'm going to be interested to see exactly how it is they reached that conclusion. But we don't need to get into that sort of detail here today
Yeah,
and now.
it is. I think I agree. I think you can have that conversation maybe further down the road. We
Yes,
can,
yes,
yeah. So
absolutely.
if when we make some more progress, so the one characteristic of this of the MOU regime, when the MOU model we had was that it wasn't regulated, so it varied from one to other. The quality of MOUs varied from community to community. It also varied from company to company. Companies that are more generous or that are more attuned to to ESG, to sustainability, tended to have better and more quality MOUs. Also, a lot dependent on the community's negotiating strength. Also, a lot depended on the communities themselves, because where they were infighting, as there was, which was the case in a lot of the in a lot of the communities, it also affected the either the negotiation or the implementation of the MOUs. We also find the communities would choose projects that had low impact, as long as it will yield immediate benefits. And then we had quite a lot of abandoned projects, and the absence, due to the absence of mechanisms to enforce completion. I would throw more light on this part, because these projects are usually undertaken or implemented by the communities themselves, or businesses affiliated to the communities. So they don't, because of that, there was no strict mechanisms for enforcing of of to enforce completion of some of those projects. So in summary, as you see in the in the orange slices we have here, the first thing usually is to identify the communities that are relevant to a particular project or a particular operation. You bring them under one MOU. The companies would engage them, determine the projects that they wanted, and they would reach an agreement as to the amounts that the company would commit, to those projects within the period of of validity of the MOU. So the company would then release the funds when the when the releases the funds for each properly nominated project. So the project implementation under the MOU structure, are driven by the project implementation committees. This committee is usually made up of representatives from both the communities and from the companies. The companies always, in many cases, would appoint the chairman of the project implementation committee. And then these projects are carried out, as I had mentioned earlier, by businesses owned by members of the communities. So the final point to make on the slides is that the oil and gas companies may also intervene directly by addressing identified development needs outside of the MOUs. So in some cases, the companies would provide additional maybe additional projects that are not covered under the MOUs where it deems it necessary, or where it also has the where it deems it necessary or expedient. So now, why did the governments pivot away from this model? Why did Nigeria adopt the ACDT model, like a legislated CSR model? And the first thing I wanted to point out here was that the MOUs as MOUs had a lot of drawbacks. You can even you can glean some of them from the previous slides. There were a lot of issues. There were a lot of operational issues, implementation problems, and then there were a lot of accusations by communities that the oil and gas companies were reneging on the MOUs. I had mentioned that in some cases there have been courts, there have been litigation, right, seeking to enforce the provision of the MOUs. There was also a sustained feeling in the Niger Delta that what they benefited, via this CSR was only an insignificant fraction of their resources that are you know produced in their communities. And then there was a lot of sabotaging as well. Oil and gas facilities were sabotaged. There were disruption in operations, and oil and gas companies blamed the communities, but ultimately this was a lot of loss, for the country. For any day that there was a disruption, as there's disruption in production, the country loses a lot of money. And there was also the hovering threat of re-emergence of militancy. There has been in 2009, the Nigerian government reached an amnesty deal with the militants, and that put an end to that wave of militancy. But even after that, another group emerged. So there was always another that fear that militancy was going to re-emerge, and as a result, the government needed something more actionable, from their perspective, and that was why whose community development trust was one of the mainstays, of the petroleum industry bill, when it was introduced in Nigeria. I think it was introduced around that's the same period, 2009, or thereabouts, even though there were earlier iterations of that. I will leave Ibrahim I'll bring Ibrahim in now to pick up from
Take
the
things
next
from here.
slide. Yeah,
Very
yeah,
good.
I think so, yeah. So I'll get a sip of water. Ibrahim.
Thanks, Lotana.
Yeah, thank you very much, Lotana. Now, flowing from what Lotana had shared, the challenges with the MOU regime was quite enormous. Disaffection among the community members, focus on the federal government of Nigeria. There was pressure on the government because the people were not getting as much as they deserve. And that led into the enactment of the PIA. Just to say that before the Petroleum Industry Act was enacted in 2021, There were several attempts by the government that failed uh, because uh, because of lack of alignment as to what should be due or given to the host community. Eventually, community voice prevailed, and the legislature did the needful to have the law enacted in 2021. Generally, the focus of the law is just to give more to the community where these resources are being explored, are being extracted, and just it's a way of having shared prosperity among community members and community stakeholders. And the objective is to ensure that the people have something tangible to show for the resources that are mined and explored within the environment. So a whole chapter is dedicated to host community development trust under the PIA, particularly chapter 3 of the heart is simply on the host community. And the objective is as outlined here, which is to bring about more socioeconomic impact, more development. If you go to the rural and the host communities, you'll be amazed at what you see. It disconnects between millions of barrels that are being produced and the kind of life that the people around they live, the amenities they have, and what exactly that they need to survive. So that's being the case. The PIA bringing about the host community development trust is to change the narrative and the landscape of CSR engagement, which was before now, used to be voluntary. So the MOU era was mainly at the discretion of the IOCs and having MOU just to give the community the needed comfort of getting the social license to continue to operate. Now, so next slide.
Can you, Ibrahim, can you pinpoint where did the idea of the HCDT originate from? Did it originate from the companies saying that we need to find a more structured way of doing this, or did it emerge from the communities? Did people say, look at this other jurisdiction, they're doing this, we should do this? Do you know that? You might not know that, but if you did know
Yeah.
that would be interesting too.
Yeah, interestingly, during I think Lieutenant was involved as well during the process of enacting the law, the public hearings, and the submission from various stakeholders. One major issue that was prominent at that time was issue of accountability and lack of definite structure, and that was the main driving force. What led to the government to adopt a measure or the HCDT model that will make the contribution or the support from the IOC more statutory than discretionary or subject to contract. That is one. Question around accountability, persons and stakeholders to be held accountable for misappropriation, misapplication of community resources. Now, with respect to other models, we look at what is being done partly in Brazil, uh, uh, in India, like I think Lieutenant mentioned some of that, but the framework entirely different. And I can say this, that Nigeria um, is leading in the initiative of experimenting statutory CSR to the host community. So it's a total deviation from what you've seen or what is being practiced elsewhere. So this model was brought about as a result of the peculiar concern and mismanagement of the MOU regime. And that was what really prompted that. So if we had taken or borrowed initiative from what is being experimented in India, in Brazil, or partly some part of Canada, then this is an improved version that is designed to address the local concern
Nigerian
of our people.
experience.
Yes.
Yeah, it's very customized. That's very good. Some people talk about how there's a power, information, resource, and expertise imbalance between, for example, petroleum companies and communities. So I'm imagining that you're going to be able to elaborate on how the HCDT enhances the ability of companies to achieve their social license to operate from host communities in the Niger Delta. Is that correct?
Yes, very well. I'll be discussing that. The entire framework of the ACDT speaks to the commitment of the company mandatorily to contribute towards community development, provide critical development intervention in areas of need that have been identified. So just to speak to this slide, the host community development trust provision of the PIA requires that companies should incorporate host community development trusts at the time they are commencing their operation. And as a matter of law, which is mandatory for all IOCs, is to incorporate host community development trusts for communities that falls within their areas of operation or the catchment area. And for some communities that are along the shorelines, those communities are not directly impacted with respect to land acquisition. They've not lost any land. They still have their land as it is, but then these communities are likely to be impacted by oil spill. Whatever happened offshore would impact the shoreline communities. So the PIA has taken into consideration the potential exposures of these communities to oil spill that may happen offshore, and they are now categorized or are to be considered as host community, but they are littoral community or shoreline communities. And the IOCs are required also to incorporate and set up host community development trusts. Now, in the oil and gas sector, you have parties coming together to embark on projects, to do joint exploration. So you have the joint operating agreement, and you have the operator representing the interests of the licensees. And where you have a joint operating agreement, the operator is responsible for undertaking for establishing the host community development trust and for contributing the 3% that we'll talk about in details in the next slide into the host community development trust. Now, the settlers, the licensees are the settlers. They are the license holder, the companies that are given the authority and the power to go and explore, carry out oil exploration in communities. They are required to consult with the host communities, or the host communities, principal stakeholders in each of the host communities in the bid to set up the host community development trust. Yes, there are time frame under the law. Like I said, this law came into effect in 2021. And prior to that time, there were MOUs that were still running before the law was enacted. And by the requirements of the law made it very clear that 12 months from the commencement of the enactment of the act, that companies should go set up host community development trusts and transfer all their existing MOU obligation into the trust for the trust to continue. There are different timelines that apply to different operations. There are certain facilities that are designated oil and gas facilities for which the operator expend money to maintain and to use as part of its operations. For those communities, wherever they are located within the host communities, the operator, the licensee, as the case may be, is required to set up host community development trusts for the benefit of those community. Interestingly as well, for field development plan, before the commencement of oil exploration or developing a field, the regulators want to know what plan you have for the communities. So before they approve your field development plan, they want to see your plan for the community. What are you doing? Steps you are taking towards incorporating and establishing host community development plan. Until that plan is produced, the step-by-step activities that will lead to the incorporation of the host community plan is produced, the regulator will not approve your field development plan. So you cannot explore without having a plan to set up host community development trust. Now,
very good.
This is the
So can you just clarify this sort of governance structure here? I take it there was no such formal structure for the MOUs prior to this. It was just informal. It was possible, I suppose, a particular company with a particular community could have a very structured governance approach such as this, but it wouldn't have to. And it could address environmental impacts, but it wouldn't have to. Whereas now, this sort of structure is required. Is that correct?
Yeah, very well, correct. And Lieutenant mentioned earlier that under the MOU regime, what you had at that time was implementation committee. And these implementation committees were just individuals, selected individuals that the IOCs maybe felt comfortable working with. These implementation committee members were not true reflection or representation of the people of the community, because we've seen instances where the implementation committee members were only out for their own self-interest as against the larger interest of the community. So you have under the MOU, the implementation committee with a secretary, with the chairman of the implementation committee, and few selected individuals from the community without any particular adherence to demograph, inclusion, inclusivity. So it could be just anybody from the community. So now, away from that is what you now have a new model under the Host Community Development Trust. Under the Host Community Development Trust, what the government has done is to have a framework, a governance framework that would allow for transparency, accountability, efficiency, and it will ensure that persons with the right competence, with the right character, are the one in charge of administering community benefits. No longer in the hands of selected individual, no longer at the mercy of the IOCs who may decide who to work with, who not to work with, right? Now, the approach is tailored, the framework is clear. So starting from the licensee, who is a settlor, the license holder, the obligation is to incorporate the trust. Second, to contribute 3% of annual preceding year OPEX into the trust for the benefit of the community. Now, the settlor also is required, unlike under the MOU, where there was no needs assessment that was conducted, right? Under the Host Community Development Trust framework, needs assessment will be conducted by the settlor to identify areas of critical needs and development interventions in the community. That needs assessment will now culminate in what you have as community development plan, which is the development roadmap to take the communities out of poverty, out of lack into sufficiency. What is to be done? How is to be done? How much is to be spent? Those details are in the community development plan that is produced from the needs assessments. Now, the IOC and the settlor in this case, though they are not in charge directly, they don't have overbearing influence on the activities of the trust, but at the formation stage of the Host Community Development Trust, they are required to take certain critical steps and decisions that will help the trust to run and be more effective. One of such is the appointment and selections of the Board of Trustees. The Board of Trustees are the apex body of the Host Community Development Trust. They are the one that decides, supervise, provide governance, leadership towards achieving the objective of the Host Community Development Trust. So the settlor midwife, and in consultation with the community stakeholders, appoint persons of credible character and competence to be on the board of director of the Host Community Development Trust. So they provide general oversight, and also they appoint the fund managers. I'll talk about that soon. And when we are talking about the funds, the fund structure. So they appoint the fund managers that manage the reserve fund of the trust. They ensure the appointment of the management committee of the Host Community Development Trust as well. So that's the function of the BOT. There are qualifications. The way it's done, the settlor goes into the community identify the chiefs, the local chiefs, the women, the youths, different bodies, have a conversation with them on the objective of the host community trust, what they want to achieve, where they need them to come in, and for them to present themselves forward to be part of, to serve as a member of the board of trustees. Now, these communities and these individuals in these communities now send in their application to serve on the board of trustees. Now, for you to identify and be sure that a prospective applicant is from a community, you request the chief from that community to write a letter of recommendation, confirming that this individual is from our community. That process is now subject to scrutiny by the settlor in line with the criteria set out in the Act, one of which is, one of which is the persons must be competent, of high integrity, right?
Right.
At all material times. And there are grounds for which persons should not be appointed as members of the board of trustees. These grounds are when someone is of unsound mind, has been convicted for crimes, issues around bankruptcies of the individual in the past. All these persons are ineligible to be appointed into the board of trustees, and the set law ensures that the provision of the act is adhered to and implemented. So when the BOT is constituted, the BOT now appoint the fund managers to manage the reserve fund of the trusts. The BOT equally ensures that the management committee is set up. Now, the management committee has two sides, the executive management committee and non-executive management committee. The work of development, CSR engagement and implementation is a serious work. Under the MOU regime, there were no expertise, there were no need for those competencies to be available in order to drive the development process. And that was one of the reasons why it failed largely or did not yield the desired results. Now, under the HCDT model, the management committee, the executive members are required to be experts, lawyers, project managers, engineers, and chartered accountants. These executive members are saddled with the responsibility of day-to-day operations of the trust, i.e., identifying projects, bill of quantity for what is to be spent, how much is to be spent, right? So members of the management committee must fit into the specified criteria and qualifications required under the Act. Then you have the non-members,
Non-executive.
non-executive members. Now, these non-executive members, yes, they fill up the numbers to reflect equity, equitable distribution across the communities. However, the executive members need not come from the communities because the communities may not have the right competencies that will provide, that would serve on the management committee. The laws allow them to go out and get people, individuals who are not from the community to help the community, and these persons are entitled to remuneration. So down the line, you have the advisory committee. The advisory committee is what you can liken to community liaison officers. These are they are the closest to the community chiefs, the women group, the youth group. They are part of the community. They come from the community. They sleep in the community. They are not anywhere outside the community. They feel the pulse of the people, communicate it to the management committee. The monitor piece ensures that there is no vandalization. The projects that are being executed in the community take benefits for those, and community members are part of the works, the construction work that are going on, the supply works, and they ensure that all interests in the communities are well, represented in the course of administering the trust. Now,
But hold on a second. I can see that this creates a very structured process with very clear accountability and responsibilities all set out, which arguably should definitely enhance the likelihood that things are going to be done, and they're going to be done properly, and they will be reflective of the community interests and desires and so on. Would I be correct to say then that what this is creating is a kind of uh, a way for communities, governments, and businesses to work together to develop customized approaches for those communities that address environmental issues and ensure compliance with environmental regulations and human rights and that sort of thing. And this kind of represents a very localized sort of capability to do this, in addition to conventional government regulators that are supposed to be regulating on environmental issues and human rights issues. Now you have this sort of community-related entity that has that responsibility to ensure that things are done properly within the community. Is that correct?
Yes, very well. You are correct. And Lotana made some allusion to this earlier. It's a collective responsibility because all the parties have roles to play, from the
Right.
regulator to the settler to the community, the BOT itself, the MACOM, the ADCOM,
Very
they
good.
have
Very
collective
good.
responsibility. Now, for the regulator is to ensure that the settlers, the licensees comply with the provisions of the law. Right,
Right.
very important. In terms of environmental protection, the PIA is very clear in other provisions, made provisions for environmental remediation fund, which, I mean, the licensees are required to make some contributions into that fund for cleanup of the environment um, whenever there's need for it. Also, there's a decommissioning and abandonment fund that helps to restore the environment back to its original state when the licensee are done with the operation in the local communities. So there are a lot of safeguards that speaks to environmental sustainability, restoration and preservation under the PIA,
Very good.
under the PIA itself.
And just to be clear, the settler is the company. It's the
Yeah,
licensee,
the
right?
licensing,
Okay.
yes. Yeah,
Right.
very
Right.
Yeah,
correct.
I think the term set law is just from the
From
trust
the,
law. Yeah,
yes, from
where
the law itself.
yeah.
Okay. Okay. All right.
So,
Fair enough.
yeah, so speaking to the fund, and just to mention that under the law and the regulations, mismanagement, which was a practice under the MOU, misapplication and misappropriation of community fund, of this fund that I'm about to explain now, it's a criminal offense and is punishable. So if you divert projects that are meant for community A to community B, you are in breach, in violation of the law. If you misappropriate fund, i.e., what is not in the community development plan, and without approval, you decide to embark on a project of your own, that itself is a violation which is punishable. The anti-graft agencies have been given the responsibility to ensure prosecutions of trustees, management committee members that violate the provisions of the law. So the 3% OPEX I'd mentioned earlier of the preceding years of the set law is to
Sorry,
be
Abraham,
paid.
just one more question before we get into the financial side. Um, I think I heard this, but I just want to confirm that issues such as ensuring that women's voices and the voices of children and so on are all represented on the structure somehow. Is that correct? That the law itself requires that?
Yes, the law requires that diversity and inclusion. You have express provision under the law requiring that the representation on the board in the ACD church should reflect the diversity and the demographic of persons within the community. And what we've done is to even insist on certain positions being occupied by the women and youth, particularly, yes.
Very good. Okay. And I assume there's kind of an assessment process for determining that the voices of women, the voices of children, the interests of women, the interests of children, and so on, are all taken into consideration.
Yes,
Yes.
and how that is done, how that is demonstrated also is in the CDP, the Community Development Plan and Needs Assessment. So you identify the needs, of children, you identify the needs of the women, the needs of the youth in setting up the Community Development Plan. Can you
Very
still
good.
hear me? Yeah.
Yes, absolutely.
Okay.
Absolutely. Yes.
So to the fund, the 3% fund is to be paid into the trust account. The trust is required to open an account with a commercial bank, and the accounts, it's divided into three categories. You have the capital fund account, the reserve fund account, which I talked earlier, and the administrative fund account. The capital fund account is for capital projects, schools, factories, hospitals, road construction, major projects, and 70% of that 3% will be paid into the capital fund account. Then you have the reserve fund account. The reserve fund account, as the name implies, is the account that holds 20% of the 3% for such a time when the settlor is unable to fund the trust account, maybe by reason of lack of operation. There's no OPEX expended for that year. The trust will carry on with the 20% in the reserve fund. The reserve fund is invested, and the responsibility of the fund manager appointed by the BOT is to manage and multiply whatever is paid into the reserve fund for the future benefits of the community. Then you have the administrative account. The administrative account is administered by the settlor to oversee how the trust functions, i.e., payments of remuneration to sitting allowances to BOTs, management committee and advisory committee, rent, and other logistics. Now, under the old regime, there was no clear-cut provision for that. So what you see is the implementation committee members try to take care of these needs by making some representations that will enable them secure contract and benefits for themselves.
Right.
So just to do away with that, the law is very clear. The law is very clear in ensuring that the administrative fund is available and it's expended for
Properly.
assuring effectiveness of the trust itself.
I'm just noting that we're running a bit short of time here. So
Yeah.
just please carry on.
Okay,
Yeah.
okay. So the operationalization is what I've talked about from the incorporation. You have the needs assessment, community development plan. The selection process. I've explained what the selection process look at and how is being done. The fund distribution, the 3% is paid into the various accounts I identified earlier. And when it's paid, a distribution matrix is drawn to allocate the monies to the various communities that fall under the host community development trusts. Next slide. So there've been challenges. I mean, it's a new process and it's been improved upon. So we've seen issues around litigations where community members, as a result of infighting and agitation, as to who will serve on the committee, decide to go to court to stall
Right.
the process, right? So we've seen issues on that. Also, the wording of 3% OPEX under the law seems to be some ambiguity because some are certain of the opinion that 3% of the global apex, OPEX is what is required as against specific production expense within the area of production. So no clear delineation and definition of host community in relation to deep waters. So that is at the discretion of the National Population Commission and the regulatory authority, the NUPRC, which is a Nigerian Upstream Regulatory Authority, to determine. This is subject to political interference, as some politicians want to take the benefits of their own community, even when they don't fall within the host community. So it's difficult also for community representatives to meet the anti-bribery and corruption policies of some of these IOCs in the course of due diligence verification of persons that should serve on the board of trustees. So the settlors still likely responsible for the ACDT funding. So the chief of all that obligation is to ensure that the 3% is paid as at when required under the law. I think that's about that for me.
Yeah.
Yeah. So Latana,
I
you
think
can just, yeah.
I think the next slide is just, I mean, basically both of us. You can just jump in anytime. But what we wanted to put out here is like early observations, things we've observed within the 5 years of of the law. I think most ACDTs are not all of them. Some of them are still quite young. But the first thing we've noticed is there's a reduction in the number of CSR initiatives by oil and gas companies. So following the ACDT model, emergence of the ACDT models, most companies collapse their CSR activities, into the ACDTs, and this is to the detriment of non-Niger Delta communities. So several CSR initiatives that addressed persons who are not within the ACDT or within Niger Delta, suffered as a result of the legislation. I think there are two reasons for this. Some of the oil and gas companies still believe that the 3% OPEX is a lot of money to invest. So if they are compelled, to invest it, then they wouldn't want to. They don't have to incur any other. Maybe they don't have any other. Budget, to embark in other CSR activities. And another reason could be that having a clear definition of what the CSR obligations of these oil and gas companies, what it meant was that many of them went to just meet the minimum obligation that they have. Yeah, and that's once they tick off that box, they were okay. Then another thing we notice is easier community engagement, and this is on the positive side, especially from the perspective of the oil and gas companies. Now there is a clear entry point instead of dealing with multitudes of communities, multitudes of families with different needs and different requests and different opinions. Everything is just channeled through the ACDTs. So the responses of most oil and gas companies, if they are approached by communities or families, will be for them to channel whatever whatever their needs were through the relevant HCDTs. Another very good outcome is notes that the ACDTs are well resourced. The NUPRC, which is the regulator, announced in 2025 that the ACDT fund nationally have reached approximately 373 billion naira, which is approximately 263 million USD, and about 536 community projects have been implemented or are being implemented. So this shows a lot of is a testament, is evidence that the HCDT the model is yielding the intended outcome. And then much to our relief as well, from speaking from the oil and gas company's perspective, is a reduction in sabotage and the disruption of operations. This is still anecdotal, of course, but from where we stand, we've noticed a reduction from that. And you can trace this reduction to the provision of section 257 of the PIA that states that any act of vandalism or sabotage or civil unrest that occurs, the communities were going to bear the brunt of that, because the oil and gas companies would be able to deduct the cost of the repairs of the damage, from the damages cost, from the 3% OPEX that were to be contributed, as a result. So as Ibrahim had alluded, the advisory committee, they are always on the lookout, to ensure that all this sabotage or any threats of sabotage or threats of unrest, that it's brought to the notice of the HCDT, which would then act to ensure that it doesn't happen, and so it doesn't affect the contribution to be received from the settler.
Very good.
Yeah.
Just a couple of follow-up questions, and this is, I know we're kind of in overtime, so I appreciate your and the indulgence of the people who are patching in, which incidentally have done a terrific job of asking questions, which I've channeled to you. I have one more question from the people who are attending, and this question is this: if the settlers are the licensees, there seems to be greater deference to them in this structure to the disadvantage of the host community. They appear to be setting more of the agenda with the regulator, as opposed to more integrative process that would involve the host community from the beginning. This is quite obvious. This particular person is saying in the way that settlers possess the prerogative of determining who goes on the board, for example, among other aspects of the process. So also, this particular person who's patching in is saying, I didn't hear about the roles of civil society in this process. So that's the one comment that if you can possibly answer. The second is, I'm sure you're both very familiar with the Extractive Industries Transparency Initiative, or NETI, the Nigerian one.
Yeah.
So I'm interested to hear your thoughts as to how this process integrates with that. So if you could possibly answer those two questions, that would be terrific.
Okay,
Yeah.
just to start with,
Okay.
the main obligation, I think I mentioned this earlier on, of the settler is to ensure the 3% contribution. That's a principal obligation, because without the fund, the settler will not, the trust cannot really function effectively.
Right.
Second to that, it's the initial setting up, right? The establishment of the trust. Like I said, the settler is saddled with the responsibility of ensuring that eligible individuals, so not really at the sole discretion of the settler. The act itself provides guidelines on who should go into the board, or persons who should be appointed into the board. Also, the act is clear, said the settler in consultation with the host community. So what it means that the settler cannot on their own decide these are the people or the person we want to work with. They will have to follow the guidelines. They have to go to the communities and consult with them, make publications in local newspaper, call the local town criers, have sensitization events such that everybody, including children in the community, they are aware that something is about to happen. Now, the legislation sets the tone for what and how this is to be executed. It's not, I mean, at the point that the bill was still under consideration, there were wide consultations, community contributions, civil society contributions, and all interested stakeholders made contribution into the bill. More particularly, when it was time for implementation, the settler went down to the communities, organized different programs at several levels just to bring everybody on board. So that is to say that it's not, I mean, under the MOU, yes, that assertion may be completely true and right. But under this regime, the settler cannot lord it over them. The trust is an incorporated entity with a perpetual succession, with a mind of its own, can take its own decision in line with the guidelines and the framework under the Act. And to speak on the 90 components briefly,
Yes.
at the point of determining what is the 3% OPEX, what you want to consider I mean, what 90 will be looking, I mean, the next audit, if they look in this direction, and how the nexus between the data and the information they have and what the settlers will be doing. I mean, in terms of contribution to the trust. For instance, total OPEX for the preceding year. What are the work programs executed for which the approval of the government interests were given, money released, expended, the purpose for which those monies were used, for what project, for what work program. Now, this will be identified and declared by the settlers and forms the basis upon which the 3% OPEX is computed and calculated, right? So the 3%, 90 will be able to, from the 90 and assessment report, they'll be able to see and determine, okay, fine. These were the activities for the preceding year for which source this amount, that amount were approved and expended. Now, flowing from that overall expenditure that is determined, you can have a clear insight into what 3% OPEX will be and what the contribution will be for the host community. So that's a touch point. Now, if there are issues around non-compliance with the contribution, insufficient contribution into the fund, the 90 report would flag it. And already there are agencies within the country that are already scrutinizing the process, trying to be sure that the IOCs and the settlers are doing what is required. Lieutenant, if you
Yeah,
have.
I wanted to touch on the earlier question about the involvement of the settlers. I think the reality, is that the settlers have to play a role at the beginning, because they are the ones that have the statutory obligation to set up the ACDTs. You cannot set up a trust without appointing the trustees, and that is the involvement of the settlers. But the law, as Ibrahim had mentioned, put in enough guardrails to ensure that the settler is not just acting on his own whims, that there are consultations with the community. But once the ACDC is set up, the involvement of the settler, the involvement of the settler is just to ensure
Minimal.
that it's contributes the 3% OPEX, and so that minimal involvement ensures that the ACDT, is able to act, only in the interest of the community for which it was set up. So that's I think I hope that answers the question, Professor Webb.
Thanks, Lieutenant, and thanks, Ibrahim. I would say with respect to answering that question, and also the question with respect to NETI, what I'm hearing is this very much aligns with NETI. It's basically an operationalization of NETI at the local level. It fits very comfortably with NETI and operates in a very aligned way. And just generally speaking, this entire process is attempting to create a very structured way of carrying out the relations between the company and the local community, so that it is not just at the discretion of the company as to what is done and how it is done. It's all done in this way as set out by government and overseen by government, as I understand it. Is that correct?
Yes,
That's
very correct.
Very correct.
Excellent.
Yeah.
Well, I know we could go ahead. Sorry.
I was just going to say that this is basically the last of the slides for us, and we just to
Perfect.
just
Go ahead.
to express our positivity, optimism, regarding this HCDT model. We think it is different from the previous, very starkly different from the previous initiative that have been implemented by the government for the benefits of the Niger Delta. As you can see on the screen, we've highlighted some of them: the derivation under the Constitution, the Niger Delta Development Commission, where the oil and gas companies contribute 3% of their annual budgets. The setting up of Ministry of Niger Delta Affairs, for the benefits of the Niger Delta. Also, another project, the HIPREP, which was a commitment of 1 billion USD that is also funded by oil and gas companies. We think the HCDT model is different, and we have more optimism towards HCDT, because it is community driven. It's done by the government, it's done by the community for themselves. It puts the responsibility of the success or the failure in the hands of the communities. And we think that the structures, the governance structures, as we've seen, as Ibrahim has eloquently outlined, shows it gives confidence that the government really meant for the ACDT, to succeed, and has put everything in place for it to achieve the intended goals. Ibrahim, I don't know if anything in ending, because this is the last slide.
So, Ibrahim, did you have anything to add? I'm not hearing him.
Yeah, so please go ahead.
Let me say this, that Lotana and Ibrahim, you've done a terrific job of condensing down what is clearly an evolving story and a very complex story. And I think we can say that this is an attempt. It's early days, so it's not clear at this stage whether or not the attempt will be successful, but it's a real attempt to come up with a much more structured approach to ensuring that the voices of communities are heard and their interests are being reflected, and that there's some assurance that the money will flow to those particular projects. It will not get siphoned off for something else. There's accountability. And so, I mean, it's early days. We'll see how it goes. But I think you've done a superb job of presenting the story to this stage of time. And I would like to, on behalf of Toronto Metropolitan University and specifically the Institute for the Study of Corporate Social Responsibility, I'd like to thank both of you and also the attendees to this session who've been asking excellent questions, which I've made every effort to channel to you, and I think you've done a great job of answering. So have a terrific weekend, and maybe we can do another session like this in a little bit to see how things are going further down the road.
Thank you very much. Thank you very much. I appreciate the opportunity as well. Thank you, Professor Webb, and thank you, TMU.
Thanks.